inviting none other than the President of the Republic of Botswana, Advocate Duma Boko, to come to the podium to deliver his keynote address. May we all rise, please?
Thank you very much. We may be seated, please. My Lord, the Chief Justice of this Republic, Justice G. Kitlugetsu. My Lord, former Chief Justice of the Republic of Botswana, Justice Terence Ranwa, Deputy Chief Justice of the Republic of Uganda, Justice Dr. Flavian Zeja, Minister of Justice and Correctional Services, Mr. Nelson Ramautwana, Minister of Water and Human Settlement, and also Member of Parliament for this area, the ever flamboyant and colorful Unneti Ramoha, the President of the Court of Appeal, Justice Tebogo Tau, Moemela Kosi of the village of Palapye, Kosi Ezekiel Bunzi, Deputy Permanent Secretary to the President, Me Matsidi Sobukoli, the Attorney General of Botswana, Me Marco Abraham, Justices of Appeal, Your Ladyships and Lordships, Judges of the High Court, Judges of the Industrial Court, Retired Judge of the High Court, Justice Stafa, President of the Customary Court of Appeal, Hosi Masunga, Service Chiefs, Chief Registrar and Deputies, all permanent secretaries who are here with us, Your Worships of the Magisterial Bench, the Palapye District Council Chairman, Rekabo Kitsuril, senior government officials, members of the media, ladies and gentlemen, I may recognize in a special way those that the Chief Justice hasn't in his salutation described as his friends. Those of us who are not the Chief Justice's friends. I recognize you and I count amongst you. You heard I was not mentioned as a friend. Let me thank you for summoning me here today. And when you summoned, you couched your summoning as a request. And I recognized it for what it was. You were summoning me to be here. And I had to cancel cabinet today. Fearing that if I do not appear, I may be cited for contempt. So I'm here today, accompanied by the two ministers, Ramautwana and Rera Mukhabe. I would not be honest with you if I did not tell you that I feel twinges of nostalgia standing here before all of you. And nostalgia, as you know, is a form of mourning. So I mourn that beautiful life that always brought me before and into conflict sometimes with yourselves. And we engaged in the interests of justice. I thank you very much for the part that you played. I have accumulated great learnings from my engagements with you. And I appreciate all of you with humility. I am extremely gratified by the gesture that the judges have displayed of making a financial contribution to providing access to justice. And I'm pleased that this court, and it is through no involvement of mine, is in Mahala, Mr. Ramuhat, not Palapye. Thank you very much. That the judges have led in this manner must surely challenge others to do their bit. And we trust that they will emulate this grand gesture from the judiciary. When I was invited here, I was not asked to give a speech. At any rate, speeches are what the members of the House of Lords render as their judgments. I'm neither a member of the House of Lords nor a law lord, so I will not give a speech. Your summons to me directed me to give a keynote address. And a keynote, as I'm aware, is the most important note in a musical scale. It is the starting and the ending point. And that's what I hope to deliver. And I have looked at the theme of your conference, Upholding Human Rights through Judicial Reforms and Accountability. And I propose to engage with this theme of your conference by offering 4 submissions. In the first, I undertake a brisk survey of our present reality, and I canvass a short list of our ambiguities and flaws as a legal system and the enterprise of justice. Under this submission, I will call upon Charles Dickens to take up the task and make some of the arguments or the points for me. My second submission will peel off a few layers of our legal system and examine their implications for human rights. In my third submission, I hope to urge a more organized, careful, but sustained effort to develop our jurisprudence. And I suggest that this requires the mobilization of the entire legal profession, including legal academics. I will also engage in an examination of transjudicial dialogue and what it has portended and may portend for the future. I will deal briefly with what the Chief Justice has raised, the establishment of a constitutional court. And then I'll conclude by trying to weave together some of these strands of thought in support of a reform agenda. The Ugandan team is here to look at our customary law and its practices. And this reminds me that what we call the English common law is in fact a distillate of the customary laws of England. That there was a time when itinerant judges would be dispatched from London to go to the different parts to hear and resolve cases. And they resolved these cases in accordance with the customary laws of the place where they sat. And at the end of their engagement, they would go back to London where they interacted amongst themselves. And in the fullness of time, there was a harmonization of the principles that they had gleaned from those customary laws and practices. And this is what then became the common law common to the entirety of the realm. And so the common law developed largely through a writ system. You needed to have a writ that related to the claim or the problem that you were presenting. And if there was no writ that suited your cause, you had no claim, no cause of action, no relief. This was a very rigid system, and the relief that was granted would be compensation. So, aggrieved by the rigidity of the common law, the litigants began to petition the king through his spiritual advisor, the Lord Chancellor. And the king authorized the Lord Chancellor to resolve some of these problems and niggling disputes that the common law rejected. And the Lord Chancellor would provide some relief. So alongside the rigid common law, developed another body of law, which became the law of equity. And because of this parallel arrangement, there was a conflict between the law as such and equity. And so the principle, as they expressed it in their lawyers' Latin, was aequitas sequitur legem. Equity follows the law. Meaning, the conflict between equity and the law was resolved in favor of the common law. And this is how it went for some time, until a point where the law now followed equity. But these were parallel systems of justice. Equity was administered now by the Court of Chancery. The Court of Chancery. Its role was to provide justice where the common law failed or fell short. And so one assumes that all the problems were now settled, because if the common law failed, equity stepped in. But Charles Dickens, in his seminal book Bleak House, describes the court of equity, the court of chancery. And I pick just a little part in order to make a few observations and suggestions for reform. It says, on such an afternoon, if ever the Lord Chancellor ought to be sitting here, as here he is, with a foggy glory round his head, softly fenced in, with crimson cloth and curtains, addressed by a large advocate with great whiskers, a little voice and an interminable brief, outwardly directing his contemplation to the lantern on the roof, where he can see nothing but fog. On such an afternoon, some score members of the High Court of Chancery Bar ought to be, as here they are, mistily engaged in one of the 10,000 stages of an endless course, tripping each other up on slippery precedents, groping knee-deep in technicalities, running their goat hair and horsehair warded heads against walls of words, and making a pretense of equity with serious faces, as players might. This is a searing indictment of the Court of Chancery, the Court of Equity, the Court of Refuge for those aggrieved at the rigidities of the common law. This is where they were to find succor and solace. Charles Dickens dismisses this court and notes about it. First, the dress, crimson curtains. But he deals with the process and the procedures, technicalities. And he says all this is a pretense of equity made with serious faces as players might. He goes on to say, this is the Court of Chancery, which has its decaying houses and its blighted lands in every shire, which has its worn-out lunatic in every madhouse, and its dead in every churchyard, which has its ruined suitor with his slipshod heels and threadbare dress, borrowing and begging through the round of every man's acquaintance, which gives to moneyed might the means abundantly of wearing out the right, which so exhausts finances, patience, courage, hope, so overthrows the brain and breaks the heart that there is not an honorable man among its practitioners who would not give, who does not often give the warning, suffer any wrong that can be done you rather than come here. Where? To the Court of Chancery, to the final seat of justice. It says, suffer any wrong, costly, wears you out. Only the mighty, the financially well-to-do might survive. And it becomes for them a war of attrition against those less resourced. And so we might pause and reflect as part of the reforms that we want on our own processes and procedures. How are they structured? Are they user-friendly? Don't we also find ourselves enclosed and entrapped in these legal technicalities that shut out many from accessing justice? And if that is the case about us, then what reforms are we bringing? And this arises more poignantly in our case because we know here the only court that we often describe as a court of equity is the industrial court, isn't it? With the oblique suggestion that the High Court is a court of law. So in our conception, whether we are right or wrong, there's a chasm between law and equity. That chasm in England was resolved with the Judicature Acts of 1873 and 1875, where they reformed the court system and the structure of the courts, and equity and the law were harmonized, merged. I'm not sure where we are in that regard here. They did it in 1873, and 2 years later realized they needed to do a little more, so they improved what they had done in 1873 with the Judicature Act of 1875. Where do we stand in relation to law and equity in our own country, in our own jurisdiction? I know that we have equitable remedies in the law. We have them, even though sometimes we want to separate law from equity. We have specific performance in the law of contracts, an equitable remedy from the English common law. We have actio quanti minoris from Roman law. It's an equitable remedy. actio redibitoria. It's also an equitable remedy. Habeas corpus, we have a number of them. But we still believe that equity and the law are separate and distinct, and equity belongs not in the regular court system, the High Court, but in the industrial court. Maybe we need to resolve this jurisprudential puzzle. And I trust that during the proceedings you will. The second aspect that also presents itself, our legal system here is layered. We have customary law, which in days gone by we used to say, and we were taught at law school, customary law is a question of fact. You must allege it, you must bring evidence to prove it. And we used to cite those Ghanaian cases of Angu versus Ata. Judge Liburu remembers those customary law classes. Customary law, a question of fact, not law. But we moved from that position, and customary law is now a question of law. We have customary law. We have received law, we always call it that. But we also have international law, public international law. And this has implications for our justice system. Customary law, we say, and we define it, is in relation to a particular tribe or ethnic group. It's not common to the whole country. Customary law of Bakata, customary law of Bangwaketsi, and such like. We've not developed to a point where this law is now common to the entirety of the country in the way that English common law developed. We still have a long way to go. International law presents a few challenges because we have what is called the jus cogens of public international law. These are peremptory norms that apply whether you have subscribed to them or not. They are called the jus cogens. So when you interpret, especially in the area of human rights, but our jurisprudence generally must take into cognizance the jus cogens of public international law. The second aspect are what are called obligations erga omnes. They apply to all as well, not quite at the level of the jus cogens. The jus cogens is now part of what is called customary international law. Obligations erga omnes, and I'm not at the level of treaties, but these are obligations that also bind, and we have to take them into account. It's a very complicated jurisprudential landscape. And then, of course, we have treaties and obligations. And we know, because we are a dualist or dualistic jurisdiction, these treaties and obligations that we sign and we ratify and we praise ourselves as a country Botswana has ratified this convention, and we stop there and we do not domesticate. We do not incorporate those treaty obligations into domestic law. It creates a problem sometimes, because now we have to go to the canons of interpretation, and that's the challenge that judges face. And there you have to wrestle with this has not been incorporated. Is it of any force and effect here at all? And this question arose in the Dow case, 1992 Botswana Law Reports, page 119. But Justice Amisa deals with this question at page 154 in relation to the OAU Convention, which had not been incorporated. And he says, the laws, the provisions that he was dealing with at the time, could not be interpreted to contradict or violate the OAU Convention. But this can only be done in a limited situation where those provisions under interpretation or consideration are ambiguous. If there is ambiguity and you are interpreting, then the judge is free to look at the international instruments. But if the law expresses itself violating those international treaty obligations, but expresses itself with what Judge Martin Horwitz in the Dow case called irresistible clearness, then the judge has no choice but to interpret the law to conflict with those international obligations. So these are the issues, real issues that you wrestle with in your work. And you have to resolve issues about human rights. And you are going increasingly to deal with some of the most complex around issues of gender, as in sexual orientation. You're going to have to wrestle with that. And when they did in Ushua Kanani versus the state, the court said there's no provision in our constitution comparable to what was in the South African constitution that mentioned sex. He said, no, it's not there. So this thing of sexual orientation does not apply here. That's what our court said. And our academics must interrogate. This is the development of our jurisprudence. But the court did come back in later cases, signaled first that if this case came back to us, we are likely to decide it differently. And it almost did in the Lekabibo case. And the court took an approach that was different from Kanani. Very interesting. This is jurisprudence evolving in our hands, before our eyes. Not in my hands, in the hands of the judges. I'm just an advocate. It's the judges who must then render. Because as Oliver Wendell Holmes says, prophecies of what the courts will do in fact and nothing more pretentious is what is meant by law. So we sit, we guess, we think, what is this judge likely to do? So we need to understand the judge. Who are our judges? We need to know you. So that when we are sitting in chambers or wherever, guessing what you are likely to do or say in relation to a live controversy, at least we have some understanding of your thinking, of who you are as a person. So it is important for us to know our judges, and that's the cardinal rule in legal practice. You don't start by saying know the law. You say know your judges. Because prophecies of what the courts will do in fact, and nothing more pretentious, is what is meant by law. So the judge who carries baggage, we all do, intellectual, cultural, all sorts of baggage. We carry that baggage. And it is that baggage that shapes the prism through which we see reality. And sometimes the reality is refracted because of the prism through which we view it. And so when you appear before a judge, there's a clash, there's a tension of perspectives, of baggages that the advocate carries and the judge carries. There's an undeclared war there. And it represents itself sometimes inaccurately in the black letter law principles in front of us. But it's bigger than that. And that is why the critical legal studies movement says to us, there's something called a judicial hunch. They say, when a judge looks at a case, before anything, there's a hunch. The judge feels a particular way and is already predisposed. When the judge goes into court, the judicial hunch has kicked in. The judge has taken a view. It may be a preliminary view. You may be able to persuade the judge, but there's a view already. This is what the critical legal studies movement argues. And they say it is important for us to understand this undeclared perspective on the part of the judge. So when you approach issues of sexual orientation, for instance, culture steps in. The lived reality that has shaped all of us. We are shaped by our circumstances, our culture, our relations, our exposure to the world. And we've already taken a view about the world. So when this case comes before a judge, the judicial hunch in this judge is already set. So we need to at least acknowledge. Because when we do honestly, we are able to engage, I think, more meaningfully. So these are some of the issues. And what do these issues do? They help us then develop our jurisprudence more honestly. We are upfront with each other. That is why in the United States, when a professor of law comes into class, he tells you, I belong to the law and economics school. This one says, I belong to the critical legal studies. When they interpret the Constitution, the other says, I'm an originalist. Meaning, I'm seeking in my interpretation to pay obeisance to what I think the framers of this document thought and felt. So it is not the Constitution moving with the times. It is the times having to adapt to this fixed and frozen position of over 200 years ago in the case of the United States, and a different dimension of reality in relation to us and the African context. So these are some of the issues. And then there's the baggage of training, the training that we've received. If you take the case of Archibald versus Attorney General, a simple case where somebody was suing for loss of support arising from the unlawful death of their breadwinner. At the High Court sat Chief Justice Livesey Luke, English law. He deals with this case and applies English law principles and rejects the actuarial method of resolving the matter and determining the quantum of damages. It goes to the Court of Appeal. 3 judges sit there. There's Justice Amisa, Justice Aguda, Justice Pakri. And you can see now this transjudicial dialogue that I mentioned. These 2 gentlemen, eminent, erudite, English law. Pakri, Roman Dutch. What is the outcome? They brilliantly deal with the principles. They canvass them, they analyze them in the same way that Chief Justice Livesey Luke had done. They come to a position which rejects the actuarial year-by-year method. And it tells in the amount that they award. The court awards an amount of 582,211 pula as damages. Justice Pakrin applies a different method. He arrives at a figure of 1,076,482. Twice the amount. If it were Lord Denning sitting, he would have said to the other 2 judges, as we read he always did when he was in the minority, he would say to them, "You gentlemen, go ahead and write your dissenting judgment." Because in his understanding, they were the ones dissenting from the correct position, which was his. But we are told that more often than not, it would later turn out that, in fact, his position was correct. And so these are some of the real outcomes where only half of what would otherwise have been awarded is in fact awarded because of this transjudicial dialogue. This one team bases on English law out and out. This is Roman Dutch law. It sounds in money, and different amounts are awarded. And so these are some of the issues I think we need to also be alive to, because they influence the outcomes of cases, and they may result in frustration, disenchantment on the part of litigants and practitioners. So we need to understand them so that we don't fight unnecessarily. We are able to place, say, this is decidedly English law approach, this is a different approach. And this takes me to the position now of the establishment of a constitutional court. The pressure from society, from all of us, has been that we must have a comprehensive constitutional review. We've agreed. We can't renege. We have to do it. We're going to do it. But we thought we should start with the establishment of a constitutional court to have a final layer which will deal with all matters or any matters before it through a constitutional lens, a human rights prism, so that it does not sneak in. It is part of the intellectual repertory, the toolkit that the judges there use. So this is one of the reasons, so that we begin to refine our jurisprudence now. We begin to develop bright lines about the nature of society that we want to have. Appreciating that judges play a big role in shaping, engineering society. Sometimes they do it and tell us they are not doing it, that they don't legislate. Judges legislate. They do, because as Owen Fisk says, to interpret, to construe, is to construct. So they are constructing in construing provisions of legislation. And so they must be informed by some broad perspective, some jurisprudential scaffolding, if we may call it that. So we are at a point now where, in my humble submission, we need to review our processes and procedures, make them more user-friendly, more accessible. They must not occlude, they must not shut out people from justice. They must come, and everything in the power of the judge must be done to accommodate the person, appreciating also that it is costly. So if we can somehow also mitigate the costs, and I've seen, contrary to what the courts have said, where it is a constitutional dispute, courts must not award costs. They must rather welcome the fact that this aggrieved citizen has come with a constitutional claim, and they must do their best to resolve it and not visit any recriminations on the person. But often we see this happening. And I think it is because we tend not to see matters through a constitutional lens. So it seems to me the Constitutional Court will force us always to foreground the Constitution in everything that we do. So I submit we need to reflect on the processes, the procedures to enhance, to augment access. We need to engage more honestly around our jurisprudence, around the principles, and we need to articulate them. And the Constitutional Court will, I think, assist. We've had cases like Udwetsi Munanya, where the Court of Appeal says there's been a grave mistake here. You've been wronged. The court itself says to a claimant, yes, we agree. Munanyana, you've been wronged, but there's nothing we can do. We are functus officio. So we can't help you. The principle of functus, or functus as they anglicize it, functus in classical Latin, functus officio. The court says there's an injustice, but we cannot help you, Ra. Go to the executive maybe the president might do something for you. So we say, because such cases do arise, as this one demonstrates, maybe now a third layer, which is the Constitutional Court, will be able, once these injustices have occurred and recurred, to be the final arbiter. And so we say we need to have a constitutional court. These are stages and phases in the development of our country, of our society, of our jurisprudence. And these stages and phases test our worth and mettle as legal practitioners. We carry the responsibility of guiding, of shaping, of stewarding a re-engineering of our society. And this onerous burden and responsibility lies with the judges. Happily, it is not mine. I can only play my limited part. But it is the judges predominantly who are in the center of it. And we urge that they discharge this function, of course with humility, but also with erudition, with prodigious learning and wisdom. And so I am just sharing with you these, my thoughts, hazarding my own views, my brisk assessment of the issues, to provoke, so that when I leave, you remain and you say, what was that character trying to say? The debate would have started. The engagement will be on. And it is that engagement that will enable us then to find some reasonable point, some intersectionality of these disparate ideas and views, so that we can then have a proper distillate of some of the best principles and values that our country can generate. And so in the knowledge economy, we will not just be consumers of knowledge. We will also contribute to the great grand storehouse of knowledge that the world is bombarding us with. We will make our own modest contribution, informed by our own circumstances and our own lived reality. This is my keynote address to you. And these are the submissions I make with utmost humility, and hope that they provoke fiercer debates, more engaged, maybe even enraged at times, discussions, and in that cacophony of voices, this voice bouncing off against this one, and in that rich blend, we produce some melody that becomes our jurisprudence and marks and defines our country, our society. And you guide the other arms of government. They look to you. They are yearning for your guidance, for your hand-holding. And I'm here to request on their behalf that you discharge that function, and discharge it without fear and without favor. Those are my submissions, with the greatest respect, my lords and my ladies, your worships. Thank you so much.
Tautona Advocate Duma Boko jaaka ne a sa tswa go buisa jalo phuthego e ka kwano a na ha jalo keynote address mme mo keynote address ya gagwe jaaka na tlhalosa gore tota mme ebile ga se speech wa go ga keynote address o tla lemoga jalo gore ke field kana ke tiro e le gore gantsi thata wa e dira ga go tsena thata mo dilong tsone tse tsa semolao mme he made 4 submissions ga simolola hela mo pego ya gagwe o na kopa jalo bone ba ile gore ke ba baretsa ditsheko ga mmogo le ba lephata la boathodi gore they need to come up with a brief survey on the current status of the justice system mo lehatsheng le le ka kwano mme a supa jalo gore dilo tse di a go saputiwa jalo ke examination of transjudicial dialogue mo e le gore go tshwanetse go nne le puisano magareng ga ba ile gore ke bone ba ile gore ke bana le sabe le ba ile gore ba iphithela jalo ba le mo the receiving end ona tlhalosa jalo gone gore go botlhokwa thata to align the customary laws with the current human rights status e le gore di teng o supile jalo gore lehatshe la Botswana jaaka o itse le dirisanya le magatshaba ka go harologana mme ebile gape lehatshe la Botswana le iphithela jalo le joine mekgatho e harologaneng e le gore e tebagantse le go kamela mahatshe ka kakaretso bogolo jang go itebagantswe le mo go tsone tsa melao mme tseo tsotlhe di salwa morago jalo ke tsone di go saena mo e le gore go teng go akaretsa jalo the treaties tse le da saeniwa le tse dingwe hela tse le gore go saenisana le dipapadisanyo tsa mahatshe a sele sengwe sa se supileng ke gone go supa gore jaanong go botlhokwa le gone go gorogile nako e gorogile ya gore lehatshe la Botswana e rile senana le saena tsone ditumalano tseo le go tsena jalo mo mekgatho ya harologane di-convention tsone tse ilo lehatshe la Botswana le tswa kgakala le ntse le di saena go botlhokwa jaanong gore di boele mono gae yaanong di localiziwe jalo di interpretiwe di kgone go tsamaelana jalo le customary law ya lehatshe leno mme nako ya gompieno re sologetse jalo gore Tautona ba a ikanisa jalo the newly appointed 6 judges ba ile gore go se chief justice na tlhalosa ka bone konthe re ga o palelwe ke tlogetswe o na supa jalo gore Tautona ha hetsa go ha keynote address wa go nela jalo kana wa go ikanisa ba ile gore ke the newly appointed judges ba le thataro ke na le tumelo ya gore borataro jo e tare go tswa gone ga yaanong ba boyano ba ka simolola tiro ya bone go ka reetsa ditsheko gone ko khoteng kgolo ya ditsheko mme borataro jo mo maineng a bone ba ne ba ntse ba lololwa ke jaaka Tautona o mona mo ditshwantsho setilo sa nna mo go sone ke sone sa tabo jalo a nna mo go sone mme ba athudi ba ile gore ba go tsenngwa gompieko kana ba go tsena gone ga go ikanisiwa ba go tsena jalo ka bongwe mme ba ikanisiwa mme ikaniso eo taba re gasa jalo ka Thamalalo Motswana re go itsisetsa ka Thamalalo go tswa gone ga re leng teng ga mo toropo ya Palapye mo Majestic 5 Hotel Conference.
Section 96, subsection 2 of the Constitution provides that I, acting in accordance with the advice of the Judicial Service Commission, may appoint a person qualified for appointment as a judge of the High Court. I have appointed these six as judges of the High Court as they qualify for appointment as such. Section 98 of the Constitution requires that a judge of the High Court shall not enter upon the duties of his or her office unless he or she has taken and subscribed to such oath for the due execution of his or her duties as may be prescribed by Parliament. Parliament has prescribed such an oath, the Judicial Oath under the second schedule to the Promissory Oaths Act, Chapter 2603. This is the oath that will be taken before me, before us all this morning. may we call on the first eminent jurist to step forward.
I, Tsekiso, do swear that I will well and truly serve the Republic of Botswana in the office of Judge of the High Court, and that I will do justice in accordance with the Constitution of Botswana, as by law established and in accordance with the laws and usage of Botswana, without fear or favor, affection or ill will. So help me God.
Judge Tsekiso yo e le gore le ene yaanong o ne a setswa go ikanisiwa ke tautona ka dithata tsa di neetsweng jalo gore re Tsekiso jaanong o ka simolola tiro ya gagwe ya boatlhodi ko kgoteng kgolo ya ditsheko, mme ba go tagela ka go latelana jaaka ke tlhalositse jalo ka bongwe jwa bone ba ikanisiwa jalo ke tautona Advocate Duma Boko. Ke tiro e le gore e nngwe ya tse di le gore it's highlight ya letsatsi la gompieno go ikanisiwa jalo ga the newly appointed 6 judges. Ke ka e le gore go ntse ka gone ka kwano seemo se tsamaya ka tsela e ntseng jalo, mme ke na le tumelo ya gore ba go tswelela ba tsena hela jalo, mme ra go tsamaya re ntse re reetsa gore go tsamaya ka tsela e ntseng jang. Mme ga ba senana ba sala morago ne maikano ao ba monwana tumalano, mme e bo go nna le yone shaking of hands jaaka e bonala jalo e le tautona a ba shika jalo to congratulate bone the newly appointed judges, mme go a go tsena yo mongwe gape ka kwano go tlhaloganya gone gore seemo ke se sentseng jang. Ke supile jalo gore ba tsena ka tatelano go ya hela ka go salana morago ga bone go bona gore go tsamaya ka tsela e ntseng jang. Tiro ke swearing in of newly appointed judges ba 6 ka palo ba 6 ka palo ka go ntse ka teng.
I, Nomsasinki Moatsi, do swear that I will well and truly serve the Republic of Botswana in the office of the Judge of the High Court, and that I will do justice in accordance with the Constitution as by law established and in accordance with the laws and usage of Botswana, without fear or favor, affection or ill will. So help me God.
wa kgotsa kgolo ya ditsheko mme Nomsamatsi le ene hela o sa tswa go dira maikano a gagwe gape le ga phuthego kgolo e kwano le gape le ga gata tona wa lehatshe la Botswana Advocate Duma Boko. jaaka e le tshwanelo jalo gore tsamaiso ke gone gore e nne ene yo ba ikanisang jalo pele ba ka simolola tiro ya bone ke seemo ka se ntseng ka teng. Mme go tswa ga go tabe gape go latela ba bangwe ba e le gore ba go tahela ba salane morago ka tatelano ya bone, mme jaaka ke supile ba ba rataro fela ya
that I will well and truly serve the Republic of Botswana in the office of Judge of the High Court, and that I will do justice in accordance with the Constitution of Botswana as by law established and in accordance with the laws and usage of Botswana without fear or favor, affection or ill will. So help me God.
jalo a ntse a sekisa for 32 years a na jalo le experience yone e kalo go supagala gape ga e le gore o setse a kile a berekela jalo mo kgoteng ya magistrata mme ebile subsequently a ya jalo a bereka as registrar of court gone ka ko mme a nna jalo master of the high court go eta mo nako ya gompieko go a go tsena ga leng teng jaanong a thatosiwa maemo tota go a go nna ene moatlhodi yo e le gore le ene o tabe e le gore o reetsa ditsheko jalo ko kgoteng kgolo ya ditsheko ke mme Felicity Sitheni Sikwene ke ene yo e le gore o sa tswa go tswa jalo a ikanisiwa ke Tona Advocate Duma Boko.
Put your left hand on the Bible and raise your right and your right.
I, Lina Mugibe, do swear that I will well and truly serve the Republic of Botswana in the office of Judge of the High Court, and that I will do justice in accordance with the Constitution of Botswana as by law established and in accordance with the laws and usages of Botswana without fear or favor, affection or ill will. So help me God.
Le gofi leo ke go opelwa diata jalo mme Lina Mukibe kana Judge Lina Mukibe yo e le gore le ene o sa tswa go ikanisiwa jalo palo ya bo mme ya supagala jalo gore ba ile jalo go palo di ka nna bararo ba ile gore mo nako ya gompieko ba sa tswa go ikanisiwa mme Lina Mukibe ke mme yo e le gore o na le thutego tse di kwa godimo thata tsone tsa semolao LLB degree mme gape go na go supala jalo gape e le a legal expert with over 26 years of experience mme go supala jalo gore o simolotse tiro ya gagwe kana career ya gagwe ya a ne a simolola jalo e le mosekisi kana prosecutor gone mo makgotleng a ditsheko, mme jalo mo nako ya gompieko o ne a ntse a le ko director of public prosecutions, ke gone go e le gore o ntse a bereka te e le director kana mookamedi wa public prosecutions, mme go supala jalo gore she has previously served as a registrar ka ko court of appeal. Jaanong go tswa jalo mo bo director jwa public prosecutions kana go tswa jalo mo bookamedi jwa go etelela bone ba bosekisi jalo kana lephata la bosekisi go raya gore mme Lena Mokibe le ene o tatsa jalo ba ba sa tswang go ikanisiwa jalo gone ha o ya jalo ko high court kwa go nna moathuti bone ko kgoteng kgolo ya ditsheko, le ene hela jalo tautona o moatswitse jalo ka e le gofi le gone go mo congratulata mo tiro ya gagwe e ntšha. Ke ka ga e le gore go ntse ka teng Motswana ka kwano re ntse re eme re bata se one kana bata ka bongwe go ta go utlwa gore ba dira ka tsela ntse ja, mme re utlwe yo mongwe le ene ke yo.
I, Mtapelo Mutala, do swear that I will well and truly serve the Republic of Botswana in the office of Judge of the High Court, and that I will do justice in accordance with the Constitution of Botswana as by law established, and in accordance with the laws and initiatives of Botswana, without fear or favor, affection or ill will. So help me God.
Re ha ke Judge Ote Motlhala yo e le gore le ene ke mongwe wa ba e le gore ba sa tswa go ikanisiwa jalo ke President Advocate Duma Boko. Ke dumela jalo gore le ene hela o sala tsamaiso e ntse e diriwa jalo morago a sa tswa go bua mahoko a harologane o ta gakologela jalo mo mahokong a go na le bo without fear or favor, o dira jalo o sa dire ka boboi gape mme o sa sekegele go pehela mo tiro ya go e dirang. Ke dingwe tsa matshego a e le gore a tshegeditse tiro e thata ya balebeledi ba ditsheko kana ba e le gore ba sekaseka ditsheko ga mmogo le boathudi. Re Ote Motlhala holds an LLB degree, ke dingwe tsa dithutego tse e le gore ke tsa semolao, mme go supela jalo go le gore o tswa gakala jalo ile legal practitioner tota, mme ebile o na le experience hela e ntsi e le gore o setse jalo a kile a practice jalo kana setse ke la bereka jalo ile moa agente tota go tswa jalo mo di various law firms, o setse a bereketse tota di company tse di kemetse ka nosi ka go harologana. Go supela jalo gore he's a senior partner in a private law firm e le gore ke ikemetseng ka nosi, mme le ene hela jalo o sa tswa go atsiwa jo, mme ke supe jalo gore Re Ote Motlhala o na le experience ya over 30 years ntse a le mo industry yone ya kana tota, mme ke supe jalo gore yone ya semolao ka kakaretso ka go supela le gore o sa tswa go bereka ko tse go ikemetseng ka nosi. Mme go tsena o mongwe gape yo ke dumela gore ke ene wa bofelo jalo re mo utlwe gore ene o touch ka tsela ntse.
I, Bafinlanda, do swear that I will well and truly serve the Republic of Botswana in the office of Judge of the High Court, and that I will do justice in accordance with the Constitution of Botswana as by law established, and in accordance with the laws and usage of Botswana without fear or favor, affection or ill will. So help me God.
Yo ke Judge Bafinlanda yo e le gore le ene hela jalo o na konotelela palo ya ba setseng ba ikanisiwa ha jaaka ke tlhalositse gore ba ne ba le ba rataro. Bafinlanda ke mongwe wa ba e le gore ke bone yano ba thatositswe jalo newly appointed wa go nna judge at the High Court, mme Bafinlanda jaaka ke supile le ene hela o tshwere dithutego tse di go godimo tsa semolao tsa LLB degree, mme go supala gape ga na le LLM in public law, mme go supala jalo gore he has been a legal expert for over 29 years mo nako ya gompieko a ntse a le mo merero yone ya tsa semolao mme go supala jalo gore o simolotse tiro ya gagwe tota re ba Finlanda as a prosecutor ile mo sekisi jalo ka ko Department of Public kana tsa bosekisi tota public prosecutions ke gone kwa simolotseng teng ko mme go supala gape gore o setsa ke la bereka jalo as the registrar of the High Court mme mo nako ya gompieko ha leng teng ha o thatisiwa maemo a jana e ne e le the receiver mme go supala jalo gore ba Finlanda ke mongwe wa batho ba ile gore ba tshepilwe thata ebile ka experience ya gagwe ya dingwaga di ka heta 29 ke yone e mo tsenyang ha e mang ha gompieko gore le ene e be na mongwe ba ba ile ba ikanisiwa gape le ga ma tswetisithi ya batho kana batho ba feta 200 ba ba tsile mo phuthegong e ka kwano.
Your judges. Thank you very much.
Allow me to detain you a while longer, Mr. President. Allow me to detain you a moment longer while I invite the brand new ones together with the Honorable Chief Justice, President of the Court of Appeal, and the Honorable Minister to come for a picture on the podium.
Okay, gora gore ke ka go ntse ka te motswana wa tsoko gae re sa tswa go bona jalo ba ile gore ba sa tswa go ikanisiwa newly appointed judges ke ba go balolele motswana ha ile gore ke gona o tshuba television ya gago wa go ntse jana ka palo go ne go sa tswa go tsena re ba Finlanda yo ile gore o na le 29 years of experience antsi a bereka jalo mo merero yone ya tsa semolao go no go na gape le me Felicity Sitheni Sigweni le ene hela jalo o sa tswa go ikanisiwa jalo and she has been appointed to the High Court as a judge. Go na le me Nomsa Moatswi ke mongwe wa ba ile gore le ene o sa tswa go ikanisiwa jalo gone ha be re nna le mme Lina Mokibe ile gore ene she's a former director of public prosecutions a tswa jalo ko lephate la ba bosekisi e be go nna gape le re o teng Mothala yo ile le ene ona jalo le over 30 years of experience antsi jalo a le mo mererong ya tsone tsa semolao be go nna le Mr. Tsekiso le ene o teng gone ha o sa tswa jalo go ikanisiwa bo rataro jo go suphala gore tiro wa bone ba isimolola with immediate effect gora gore ha re leng teng ha ba simolotse jano maemo a bone ke ba bidiwa jalo batho di ba khota kgolo ya ditsheko seemo se se ka sentseng ka teka kwano gora gore ba ntse ba etsa dinepe mme ke dumela jalo gore ba tsile gape le ba masika le ditsala go ta go witnessa jalo jaaka batho ba tsena mo seemo seo mme ba sa tswa go itsa dinepe go ra go lebela jalo mo go ting malebo kana vote of thanks e tabetswa jalo ka ko the Minister of Justice and Correctional Services Mr. Nelson Ramaotwana ke eno ile gore o tabe jalo a tswalela tiro e ka kwano mme go tsweng go gora gore ke dinepe tse ile gore di teng ke tautona jaaka ile toelo gore go ntshiwa jalo tsone dimpho tse ile gore wa dinelwa gantsi thata ha tautona le kwano tabe a tshwanetse ra itse dinepe le bone ba ba rulagantseng le ba ba eteletseng pele ditiro tsa go nna jana mme a tswe jalo ka mpho go mo lebogela go bo a tsere nako ya gagwe mo nakong e telele ya go tsamaisa lehatse kana e ntsi thata go tsamaisa lehatse go ta go ema gone ha e le gore o wa thusa jalo go tsamaisa gone gore go ba netegatse gore o ba thagolela tsela mo dikganyeng tsa bone tse ile gore ba go buisana ka tsone bogolo jang e le tsone tsa semolao ke supile jalo kgante jana ga le gore tautona na bua gore le ha tsela Botswana ke nako yano ya gore le lebelele gore ka ntse ba dira ka te dilo a medisiame a meditsamaisana thata le ditshwanelo tsa setho a meditsamaisana thata le makgota ile gore le tsela Botswana le ile go one tautona o supile gape gore o lebile jalo go ne gore go botlhokwa gore go nne le mo go te constitutional court e le gore ke yone e le gore ba bitsa ba re concord ko lehatseng ya re bapile le lone ka ha e tabe e nna yone court ya bohelo yano morago ga court of appeal e le gore tabe le yone e le gore yano go tabe gore e tswa teng dikgang ka go harologana tse e le gore o dumela jalo gore di ntse di saletse ko morago tona o supile gape gore go botlhokwa gore batho di ha ba dira tiro ya bone go nne le boammaaruri tota boammaaruri ka go go the honesty ke gone mo go botlhokwa gore ba tsenye boammaaruri mo te gore go sena ope yo ka ipelaetsa gore kgang ya go kana tsheko ya gagwe ga ya rediwa sente kana o segetswe ga thoko ka lepehela una mo nako ya gompieko gora gore e tare go tsweng gape re etsa jalo one malebo mme ga go tswa go re utlwa jalo yone vote of thanks go tswa jalo ko go Minister of Justice and Correctional Services Mr. Nelson Ramaotwana. Sengwe sa dikgang tse e le gore Motswana ko gae di ntse go buiwa ka tsone go ne go buiwa thata ka dikgang hela ka go harologana gore phuthego e o ta gakologela jalo gore phuthego ya go nna jana ene ya tshwarela bohelo ka ngwaga wa 2019 mme jaanong morago ga ngwaga tse thataro go bone go le botlhokwa gore phuthego eo e te itshegetswe gone yana mme itebagantse le Upholding Human Rights and Upholding Human Rights through Judicial Reforms and Accountability. Arute vote of thanks ka Minister Ramaotwana.
Program Director, thank you very much. Mr. President of the Republic of Botswana, Advocate Duma Boko, Chief Justice Re Ketogetsi, former Chief Justice Rera Noani, Deputy Chief Justice of the Republic of Uganda and Head of the Court of Appeal and Constitutional Court of Uganda, Justice Dr. Flavian Seija, Minister of Water and Human Settlement, Honorable Ramohapi and Member of Parliament for Palapye, Honorable President of the Court of Appeal, Justice Tebogo Tau, and all Justices of Appeal here present, Moemela Khosi wa Palapye, Khosi Ezekiel Bunzi, Honorable Attorney General Mema Abraham, Permanent Secretary to the Ministry of Justice and Correctional Services, Mema Muroka, Judges of the High Court and Industrial Court here present, Retired Judge of the High Court, Justice Tafa, President of the Customary Court of Appeal, Khosi Masunga, Deputy Commissioner of Prisons and Deputy Commissioner of Police here present, Director General of DIS and your staff here present, all police members here present, Director General, Support Service Botswana Defense Force, your worships, magistrate across the length and breadth of the country, Council Chairperson Rekabo Kitsugile and Council Secretary here present, senior government officials here present, and apology, Deputy Permanent Secretary to the President, Mema Bukule. I'm sorry, my apology for murdering the protocol. My apology for that. Distinguished guests, ladies and gentlemen, we have come to the close of the first session of this conference, leading to the opening of the conference. And please allow me from the onset to appreciate and thank the Honorable Chief Justice J. Ketogetsi for convening this momentous event, which I'm reliably informed that it has been quite a long time without having the event. We thank you, Chief Justice, for this occasion. We also thank sincerely heartfelt for the President of the Republic of Botswana for your inspiring words, Advocate Duma Boko, And these inspiring words would then kickstart this conference with something tangible to deal with. And we thank you, Mr. President, because you have said it time and again that we are not going to interfere in the running of the judiciary. You are only concerned about the judiciary stepping up to the plate for the judiciary to do their job, to develop the jurisprudence of this country. You are only concerned about applying the law to the facts and simply develop our jurisprudence so that other countries can also refer to us, not us referring to other countries. So the time is now, as you gather today here, to simply become thinkers, critical thinkers. So thank you, Mr. President. You have allowed them to think. You have allowed them to get off the cages. We are not going to give you calls to decide judgment one or the other. We simply need you to step up to the plate and become critical thinkers and develop our jurisprudence. Thank you for the kind words, Mr. President. And also thank you, Mr. President, for having said that there are two schools of thoughts, the conservative and the active. They should manifest themselves in writing the judgments. They should manifest themselves in coming up with those solid judgments, those that were done in the days of Amisa, in the days of Aguda. That's what Mr. President was simple, provoking you to step up to the plate and just do that without any interference from the executive. Then you are on your own to become critical thinkers. Thank you for the kind words, Mr. President. We thank you very much. Madam Chief Registrar, your deputies, assistants, your worships, panelists, attendants, thank you for considering it important to convene this legal event. The presence of the entire judiciary here in Palapye on its own is deterrent enough to would-be criminals or suspects, defaulters, and heartbreakers to toe the legal line, lest the long arm of the law finds its way to their doorstep. So the importance of convening this kind of conferences cannot be undermined. It is an opportunity for the judiciary to gather together under one roof with some of its key stakeholders to dissect its mandate, reevaluate its processes, and seek counsel from one another and from those with expertise not normally found in the legal sphere for the improvement and elevation of the judiciary. As I understand, there are also academics from the University of Botswana and even our friends from Uganda who would also share experience as we grapple with those ideas. The theme for this conference has been coined, Upholding Human Rights through Judicial Reforms and Accountability. This theme is a movement in sync with the direction of the country is heading towards a human rights approach to government of the people, where the rights, freedoms, and the expiration of the citizenry are considered of utmost importance in modern-day democracy, where the function of the courts assists to protect these rights and freedoms and not to turn a blind eye to the existence of their violation. And Mema Moroka and other permanent secretaries across ministries that are currently grappling with the issues bedeviling Basara of our society. And currently, they have discovered a number of disturbing scenes and events out there as they move out. Recently, I was in Buteti. I also met Basara with a harrowing experience of how they are treated. At times, their properties are taken because they are Basara, they cannot own any property. At times, a Musara woman who was born in 1940, in his umang, it's written 1975, an old woman, older than my mom. She's written to be younger than me. Interact with as a violation of human rights. And I was with Permanent Secretary Ibineng. He also showed me that in their discussion, he also saw such kind of experiences lived by Basara who are part of our society and are ill-treated. So when they come to you, I'm not saying just because the Basara violate the principles of interpretation. I'm saying these are people that for long they have been subjugated to degrading treatment. So those are the issues that we interact with. Through these themes, the Honorable Chief Justice recognizes that reforms such as strict adherence to judicial case management principles, digitalization of courts by embracing the notion of smart court, child-friendly courts, more efficient ways of production of record of court proceedings is the bright future of our judiciary, which so desperately need. And again, Chief Justice, we know we are engaged with an issue of the society clamoring for speedy delivery of their judgments. And we know that magistrates, they are in short supply. We have a problem of shortage of magistrates, problem of shortage of court reporters, and appeals are not prosecuted or heard in time. And those are the issues that we are grappling with. We know your cries as Botswana, as magistrate. We know that you have also said you had short supply of magistrates. So that, Chief Justice, this conference is the appropriate forum to deal with those issues and give us solutions. Identify the problems, give us the solution, we'll implement whatever comes from this conference. My lords, ladyships, and worships, the last part of the theme, judicial accountability, is the key that unlocks justice in the judiciary. Where accountability is held sacred to this profession, there would be mechanisms and processes that ensure that judicial officers are answerable for their actions and decisions, upholding the rule of law and public trust, and ensuring transparency without compromising judicial independence. This is a befitting theme for the current climate of the judiciary. It is well-rounded to address the challenges currently plaguing our courts. And my lords, ladyships, and worships, I am confident that at the end of the 3-day conference together, you would have come up with practical, innovative ideas and solutions to the challenges in the judiciary, leveraging technology for judicial reforms in response to emerging legal issues in the digital era. And may I request that concerted efforts be made towards implementation of the resolution and recommendations made in the course of this conference in order for our judiciary to attain that world-class status we desire, and not just lip service and a tick to an imaginary box for having convened together as key stakeholders in the justice system. And lastly, your lordships, ladies and gentlemen, allow me to congratulate the newly sworn-in judges of the High Court. Your appointment to the bench is a refreshing and welcome development to a judiciary that has for years lamented that it is under-resourced in all spheres of its function, be it financial, manpower, and other aspects. So, all of you have been practicing one or the other for more than 20 years. So there are no greenhorns amongst the appointed justices. They have been there for over 20 years, others as private legal practitioners, others as magistrates, others working in the AOJ. So it is a balance from both worlds, the private and also the government system. So the appointments are well-deserved and well-made. Thank you very much. Congratulations. You therefore came in at an opportune time when the country's transformation agenda is unfolding for the betterment and development of government, the judiciary being a very key component in the efficient running of the economy of the country. I wish you well in the discharge of your new mandate and trust that the oath of office you just took remains your anchor in the cases you will preside over. And I did not desire to speak at length. Mine was just a minute task of giving vote of thanks. But may I also request all of you we have got a new Bail Act. This Bail Act is very detailed and comprehensive, adopted in 2024, and as the President and all other ministers address Kuta meetings around the country, Botswana are crying. We are currently engaged with the DPP on the question of whether they brought the appropriate evidence and facts before the magistrate, because we are told other suspects, they've got up to 10 cases of stolen stock theft, yet they keep on being given bail after bail. So we are not directing you, we are saying you work on the facts and the law, but we are saying we are dealing with our prosecutors and police officers to say whether they bring the right information before your lordships, your ladyship, and your worships, so that you will take appropriate decisions. So we are not commanding you, we are saying the current Bail Act allows the complainant also to be invited to court to come and say, why can't X be given bail if one has got a string of 10 stolen cases before different magistrates, and that person is being granted bail every now and then. So one person in Kanye says he nearly took the law into his hands by taking the gun because they have stolen all the 40 heads of cattle, and he went back to Kanye, leaving the cattle post closed with no single head of a cattle. So those are the harrowing experiences that our people are living. So we are dealing with the prosecutors to say, let them place the facts before the presiding officers so that the right person belongs or is put to the place where they belong. So we are saying, let us all read this Bail Act and be able to apply it so that our people are not tempted to take the law into their hands, which is unlawful. So we plead with you, your lordships, ladyships, and worships. And with these few remarks, I thank you very much and have a productive, wonderful conference. And we await the solutions coming from this conference so that we can do the needful by reforming the law. So we rely on you to give the directions, because ours is to reform the law. Thank you very much.
Yo inele Re Nelson Ramautwana, the Minister Kanatona wa Justice and Correctional Services, ane jalo Kharela Session 1 kana jalo ganta go simolola jalo mo maphakeleng mo moswa gompieko mo nakwa gompieko gora gore kwa go iwa jalo ko nako ya boikhutso for metsotso e ka nna le 10 me e re morago re tsudua jalo ko health break go bo go tsena jalo session 2 go ile re gone ra go bona jalo go na le mogoti Chief Registrar's Report gore go kwadisiwang te tsone di tsheko tseo pele di ka rediwa go tshwanetse go tswe report jalo mme go nna le mogoti Judicial Independence and Accountability mo go supa jalo gone gore mme one lephata lone le la ba goretsa ditsheko jalo le boathodi mme ba na le independence ba ikemetse ka bo bone le gone gore maikarabelo a tse ba di dirang jalo mo tiro ya bone ba tsa go ya pele mme ke dipuisano tse le gore jaaka go tlhalositswe this is a dialogue e le gore go to go buisana go bona gone gore mme go tswa gakala mo dingwageng tse di hitile go tsena ga mme ba ntse ba tsama ka tselentseng ja go go nna le engwe ya leveraging science and technology within the administration of justice yone e tswa jalo ka ko BUST go tabe go bua jalo Dr. Dimani Mpoele yo le gore o dila jalo le dikgang tsa bo di satellite ka tsela e ntseng jalo motswana wetso re ya go ikhutsa mme e re morago ga metsotso le 10 re tabe re boela gape gone ka kwano go ta go fa ditirelo tsa letsatsi ka thamalalo mo Botswana Television.
Well, that's where we wrap our live broadcast for this morning, which was bringing to you the official opening of the Judicial Conference, which will be on for 3 days. And there, the official opening there, of course, being given by